Welcome to the deep dive. Today we're tackling one of the most fundamental yet, well, surprisingly complex areas in criminal law, causation. When something bad happens, an injury, a death damage, how do courts actually decide who is legally responsible for that specific outcome?
It really is a deep dive into the whole chain of events, isn't it? Think about those classic tricky scenarios they always bring up.
Oh, yeah. Like what?
Well, like if person A threatens person B, right, and forces B to punch person C, injuring them, is A or B the legal cause of C's injury? Or imagine A stabs V, V goes in an ambulance.
Right.
But the ambulance crashes, and V dies from injuries in the crash, not the stab wound itself. Did A actually cause V's death in the eyes of the law?
These aren't just, thought experiments. They're real questions courts grapple with to figure out who's actually to blame.
Exactly.
So this deep dive is specifically looking at the principles governing causation in criminal law, especially for crimes that need a specific result. And we should mention, the material we're drawing on today is made available for educational purposes by the University of London.
That's right.
And this discussion is brought to you by Sinorbit Academy, Sri Lanka. We really hope this helps you get a solid grip on these key concepts.
Yeah, definitely. And good luck with your exams, everyone.
Absolutely.
So, to really understand causation, we first need to draw a distinction, don't we, between different types of crimes.
Right. You've got conduct crimes.
Yeah, conduct crimes. The offense is complete just by doing the forbidden act. Think of simple, dangerous driving.
Just the act of driving dangerously is enough. You don't need to crash or hurt anyone.
Exactly. But then you have other crimes, like causing death by dangerous driving. Those are different. They're result crimes.
Okay, result crimes.
Yeah. Result crimes need more than just the wrongful conduct. They need proof that the conduct actually caused a specific prohibited outcome, like death or serious injury or damage to property.
And for any result crime, the prosecution has the burden, right?
Always. The prosecution has to prove beyond reasonable doubt that the defendant's actions or sometimes their omissions were the cause of that specific result.
Okay, and I suppose in many cases it's obvious, like A shoots B, B dies from blood loss. Pretty clear causation.
Sure, lots of cases are straightforward. But it gets really complicated when, multiple things contribute or something unexpected happens along the way.
And that's where the law needs these specific principles to untangle it all.
Precisely. That's what we need to dig into.
So where do we start with the legal analysis? What's the baseline?
Well, the materials suggest a kind of basic rule of thumb, which is a good starting point.
Okay.
It's like this. If a person's voluntary act starts a chain of events that ends in harm, they're generally held responsible unless some later event or someone else's act makes it seem unfair or just inappropriate to blame them for the final outcome.
Ah, like that example from Activity 4.1a. D puts a wet soap bar down, wants V to slip, V slips, gets hurt.
Exactly. D's voluntary act kicked it off. The slipping and injury followed directly. Nothing really happens afterwards to make you think, hang on, maybe D isn't the one responsible here.
So that straightforward scenario leads us to the more formal structure.
Yes. The fundamental two-part structure for analyzing causation in criminal law. It's actually laid out quite clearly in the draft criminal code bill from 1989, Clause 17. You need to prove two things.
Two things. What are they?
Factual cause and legal cause. You absolutely need both.
Okay, let's take factual cause first. What's that about?
Factual cause is basically the scientific or historical question. Did the defendant's action even contribute to the outcome happening at all?
And how do you test that?
The classic test is the but-for test. Hart and Honoré put it well. Would the consequence have happened but for the defendant's act or omission?
Would it have happened anyway, essentially?
Pretty much. And the case everyone learns for the but-for test is White.
Ah, yes, White. Poison in the drink.
That's the one. The defendant put cyanide in his mother's evening drink. But, crucially, she died from a heart attack before she even drank it.
So, applying the but-for test.
Would she have died from the heart attack then, but for him poisoning the drink? Yes, she absolutely would have. His act made no difference to her dying at that moment from that cause.
So, he wasn't the factual cause of her death.
Correct. Not the factual cause of death. He was guilty of attempted murder, obviously, but not murder. So, White really hammers home, if the outcome was going to happen exactly then anyway, the defendant's act wasn't a factual cause of that result. Remember White and the but-for test.
This makes sense. It wasn't necessary for the result, but Does the defendant have to be the only cause? Or even the one who started it all?
No, absolutely not. Simply accelerating the outcome is enough. Speeding it up.
Accelerating.
Yeah.
Yeah.
Even if death was inevitable down the line, if the defendant's actions make it happen sooner, that counts as causing the death. The case for this is Dyson.
Dyson. What happened there?
A father attacked his child, who tragically was already dying from meningitis. The attack accelerated the child's death.
So even though the child would have died eventually anyway.
Right. But for the father's actions, the death wouldn't have happened when it did. So his conduct was a factual cause. Accelerating death, as in Dyson, is enough for factual causation. Keep Dyson in mind for acceleration.
Okay. And the link doesn't need to be direct, does it? Like a domino effect?
No, it can be direct. We saw that in Mitchell.
Mitchell, remind me.
Defendant punched a man. The man then stumbled and fell onto an elderly woman who suffered injuries and died later.
Ah, right. The punch wasn't aimed at her.
No, but for Mitchell's punch, the man wouldn't have fallen, the woman wouldn't have been hurt, and wouldn't have died. So Mitchell's initial act was still a factual cause, even though it was indirect.
As long as it's like a significant link.
Yeah.
Not totally trivial.
Exactly. The connection needs to be more than negligible, which fits with the wording in the draft code too. So remember Mitchell for indirect causation, satisfying the but-for test.
Okay, so factual cause.
Yeah.
The but-for test. We need some link. Could be acceleration like Dyson or indirect like Mitchell, but just meeting the but-for test isn't the end of the story, is it?
Not at all. That just gets you past the first hurdle. Now you need legal cause.
Legal cause. And this is where it gets less scientific
Well,
or judgmental.
Precisely. A factual cause only becomes a legal cause unless the court decides it's too minor, too remote, or maybe just fundamentally inappropriate to pin the blame on the defendant for that result.
Inappropriate. How so?
Well, the materials really stress this. Legal causation is ultimately a moral or common sense judgment, the court asks. Is it fair? Is it appropriate to hold this person legally responsible for this specific consequence?
So it's not just about the chain of events, but about whether attaching legal blame feels right.
Kind of, yeah. Think about that awful scenario in Activity 4.1D, D rapes V, and then V's father kills V because of dishonor. Now, factually, but for the rape, the father might not have killed her then. But our common sense, our moral compass, usually tells us it's not appropriate to hold the rapist legally responsible for the father's deliberate, independent act of murder later on. The legal cause of death lies with the father, doesn't it?
Yeah, that feels right.
Yeah.
The father's act is the direct,
Wow.
voluntary cause.
So that's the kind of judgment involved in legal causation. And another key principle here is that the harm must result from the wrongful aspect of the defendant's act.
The wrongful aspect, what does that mean?
The case of Dalloway explains it.
Dalloway. Yeah.
Defendant was driving a horse and cart, but dangerously not holding the reins. Definitely wrongful conduct.
Okay.
But then a small child suddenly darted out right in front of the cart, was hit, and died.
Oh, dear.
The court found D wasn't liable for the death. Why? Because even if he had been driving properly, holding the reins, he couldn't possibly have stopped in time to avoid hitting the child.
So the fact he wasn't holding the reins, the wrongful part, didn't actually cause the unavoidable collision.
Exactly. The death wasn't caused by the dangerous driving. It would have happened anyway, given the child's action. So the consequence didn't flow from the wrongfulness of his act. Remember Dalloway for that point.
Got it. Wrongful act must be linked to the result. And the defendant's contribution, does it have to be major? Or can tiny things count?
It has to be substantial. The law tends to ignore causes that are de minimis, too trivial to really matter legally.
Substantial. Any examples?
Think of Adams, the doctor giving pain relief case.
Right. To a terminally ill patient, might have slightly shortened life.
Potentially. But the judge, Devlin J., famously said that if the drugs were given properly for pain relief, according to medical standards, then the doctor didn't cause the death. The disease was the substantial cause. The doctor's actions were, at most, incidental, a negligible contribution. Not the legal cause, so Adams shows a contribution can be too small to count legally.
Okay, Adams, negligible contribution. What about the other way? When is it substantial enough?
Compare Adams with Bench,
Bench.
railway foreman case. He messed up the timetable checking, leading to a track worker being killed by an oncoming train.
Right.
The foreman tried to argue, well, the train driver was negligent too. But the court said, essentially, doesn't matter if someone else was also at fault, your failure to check the timetable was a significant, substantial cause of this death.
So even with other contributing factors, his role was too big to ignore.
Exactly. It was substantial. It played a real part. You couldn't just brush aside when assigning legal responsibility. So the contribution must be substantial.
Okay, let's recap that. We need factual cause, the but-for link, White, maybe acceleration, Dyson, maybe indirect, Mitchell, and we need legal cause contribution must be substantial, Benj, not Adams, must flow from the wrongful act, Dalloway, and it needs to be appropriate based on common sense or moral judgment.
You've got it. But now, what happens if something else occurs after the defendant's initial act, something new?
The chain of causation going to be broken. This is the Novus Actus Interveniens idea, right? A new intervening act.
Precisely. Novus Actus Interveniens, a new act or event that happens after the defendant's conduct and is potentially significant enough to sever that causal link between the defendant's action and the final result.
Okay, so what kind of things can break the chain?
Well, one of the most fundamental rules here, and you absolutely have to know this, is the eggshell skull rule, sometimes called the thin skull rule.
Eggshell skull rule. Sounds descriptive.
It is. The core idea is you must take your victim as you find them. Meaning the victim's pre-existing vulnerabilities, physical, physiological, even psychological, even if they're really unusual or make the outcome way worse than anyone would expect, generally do not break the chain of causation.
So if I push someone, just a light push, but they happen to have like incredibly brittle bones and suffer a major fracture, I'm still the cause.
Generally, yes. Their brittle bones don't break the chain. You take them as you find them.
Wow. Cases.
Key cases are Hayward and Blau. In Hayward, the defendant chased and threatened his wife. She collapsed and died because, unknown to him, she had a seriously weak heart.
And the court said,
her condition didn't break the chain. He caused her death by frightening her, given her condition. He had to take her as he found her. Hayward.
Okay. And Blau. That was quite famous, isn't it? The blood transfusion case.
It is. The victim was stabbed by the defendant. She needed a blood transfusion to save her life, but she was a Jehovah's Witness and refused it on religious grounds.
And she died because of the blood loss, which the transfusion could have stopped.
Yes. But the Court of Appeal in Blau held that her refusal, based on her deeply held religious beliefs, did not break the chain of causation.
Even though it was her decision.
Even so. The reasoning was that the stab wound was still an operating and substantial cause of her death. The defendant had to take his victim as he found her, and that included her religious beliefs. So Hayward and Blau powerfully illustrate the eggshell skull rule. Vulnerabilities or beliefs don't usually break the chain.
Okay, so victims' vulnerabilities are usually covered by the eggshell skull rule. What about actions by other people? Third parties intervening.
That's another major category where a novus actus might arise. The general principle here is that a third party's action will not break the chain if the defendant's original act is still considered a substantial and operative cause of the final result.
Substantial and operative. That phrase again.
It's crucial. It comes up again and again. You need to remember substantial and operative cause.
Where does that specific phrasing come from mainly?
The landmark case is Smith. Definitely need to know Smith.
Okay, Smith. What were the facts?
Soldier stabs another soldier during a fight. The victim is being carried to the medical station, gets dropped twice. Then, at the station, he receives medical treatment that was described later as palpably wrong, actively bad treatment, and he dies.
So the question was, did the dropping or the awful medical treatment break the chain from the original stabbing?
Exactly. And the court in Smith said no. They held that the stab wound was still an operating and substantial cause of death when he died.
Even with the bad medical care?
Yes. They laid down the key principle. If the original wound is still operating and substantial, the defendant is liable, even if other causes are also operating at the same time. The chain is only broken if the second cause is so overwhelming as to make the original wound merely part of the history.
Wow, merely part of the history. That's a high bar.
It is. The poor medical treatment in Smith, while bad, wasn't seen as overwhelming enough to make that stab wound just background history. So the Smith principle is fundamental for third-party acts. Memorize it. Substantial and operative cause.
Okay, substantial and operative. And we see that again with medical negligence in Cheshire.
Yes, Cheshire. Defendant shot the victim. Victim needed a tracheotomy because of the shooting injuries. Weeks later, he died from complications arising from that tracheotomy, which had been performed negligently.
So negligent medical care again. Same result as Smith.
Same result. The court held the negligent treatment didn't break the chain. Why? Because the medical treatment itself was a direct response to the injuries caused by the defendant's shooting. It wasn't truly independent. The shooting remained a substantial and operative cause. So Smith and Cheshire both show that even pretty bad medical treatment usually won't break the chain unless it's utterly extraordinary.
Is it ever extraordinary enough? Does medical treatment ever break the chain?
Well, Jordan is the classic but very rare example where it did.
Jordan. How is that different?
Victim was stabbed, went to hospital. By the time he died, the original stab wound was actually healing pretty well. But the hospital gave him an antibiotic they knew he was allergic to.
Okay.
And then they gave him way too much intravenous fluid. He died of pneumonia caused by this treatment. The court in Jordan said this medical treatment was palpably wrong, basically. Gross negligence. And it was so powerful and independent of the original wound, which was healing, that it did break the chain. It superseded the stabbing. But Jordan is seen as very exceptional, a really high threshold.
Okay, so usually medical treatment doesn't break the chain unless it's like Jordan. What about, say, police action, if they're reacting to something the defendant did?
Generally, if a third party acts reasonably, like in self-defense, or doing their duty in direct response to a danger the defendant created, their actions don't break the chain. The key case here is Paget.
Paget, human shield.
That's the one. Defendant was shooting at police, using his pregnant girlfriend as a shield. The police fired back, acting in self-defense and to arrest him. Tragically, their bullets killed the girlfriend.
So who caused her death legally?
The court said the defendant, Paget, caused her death. The police firing back was seen as a reasonable, foreseeable, and justifiable response to his unlawful and dangerous actions. It wasn't a novus actus breaking the chain from his initial act. So remember Paget for reasonable reactions to danger.
Okay, so third-party acts usually don't break the chain if these act is still substantial and operative. Smith, Cheshire. Unless maybe it's incredibly independent and overwhelming, Jordan, and reactions to danger, Paget, generally don't break it either. What about the victim's own actions after the initial harm?
Similar ideas apply, really. If the victim does something, does that break the chain? Again, it often depends on whether the defendant's initial act is still a substantial and operative cause, and whether the victim's action was a reasonably foreseeable response.
Like the Blau case again, refusing treatment.
Exactly. We already saw in Blau, her refusal didn't break the chain. The stabbing was still substantial and operative. There's an older case, too, Holland. Victim was assaulted, got a badly infected finger. Doctors advised amputation. He refused. Got tetanus and died.
Same outcome. Chain not broken.
Correct. The court in Holland held his refusal didn't break the chain because the original wound inflicted by the defendant remained the operating cause of the infection and eventual death.
Okay, so refusals of treatment generally don't break it. What if the victim tries to escape, gets hurt while escaping?
Escape attempts. If a victim gets injured trying to flee from the defendant's unlawful attack, the defendant is usually held liable, provided the victim's reaction wasn't completely disproportionate or unforeseeable. The case here is Roberts.
Roberts.
Victim was in a moving car. Defendant started making unwanted sexual advances. She jumped out of the moving car to escape and got injured.
And the defendant was liable for the injuries from the jump.
Yes. The court in Roberts said the chain would only be broken if the victim's reaction was so daft, so utterly unreasonable and unexpected in the circumstances that no reasonable person could have foreseen it. Jumping from a car to escape an assault wasn't seen as daft.
Has the daftness test been refined?
Yeah, later cases like Williams and Davis, another escape case, this time from an attempted robbery on a hitchhiker who jumped from the car and died, talked about the test being whether the victim's response was within the range of responses which might be expected from a victim placed in his situation.
So, reasonably foreseeable from Roberts, or within the range of expected responses from Williams and Davis. Are they basically the same idea? Was the victim's reaction understandable given the threat?
Pretty much, yeah. Was it a proportionate or understandable reaction to the situation the defendant created? That seems to be the core question.
Okay, now a really difficult one. Suicide. If the victim takes their own life sometime after the defendant's wrongful act, can the defendant ever be said to have caused that?
It's incredibly complex and sensitive. For a long time, the general view was that a victim's voluntary decision to commit suicide would almost always break the chain of causation. It's seen as the ultimate free choice.
But that's been looked at more recently.
Yes. The case of Dhaliwal involved long-term domestic abuse where the victim eventually took her own life. The court suggested that while psychological harm from abuse is foreseeable, suicide itself is generally voluntary. However, they left the door slightly open, suggesting it might be possible to establish causation if the suicide was directly triggered by a specific wrongful act, not just the general situation.
Triggered by a specific act? And then there's Wallace, the acid attack case.
Yes, Wallace is a really significant recent case on this. The defendant threw acid over his ex-partner, causing horrific, life-changing injuries. She suffered unbearable pain, was paralyzed, lost sight, leg amputated. Eventually, about 2 years later, she traveled to Belgium and chose to end her life via lawful, voluntary euthanasia.
And the court had to decide if the defendant caused her death through euthanasia.
The Court of Appeal in Wallace said a jury could potentially find that he did. Their reasoning was key. They said the jury should consider if the defendant's horrific attack made a significant contribution to her decision to end her life. Was her choice a direct response to the injuries and the unbearable suffering he inflicted? If so, the chain wasn't necessarily broken, even though it was her voluntary act and there was a time delay.
So Wallace suggests it's not just about foreseeability, but about the significance of the defendant's contribution and the directness of the victim's response to the injuries.
Exactly. It's a nuanced approach for these tragic situations. Remember Dhaliwal raising the possibility and Wallace confirming a jury could find causation in such extreme circumstances.
Right. So pulling these different intervening acts together, third parties, victims, what are the sort of formal criteria for something to count as a novus actus interveniens that successfully breaks the chain?
Generally, for an act as opposed to an omission or a condition to break the chain, it needs to be voluntary, independent of the defendant's initial wrongful act, and sufficient in itself to cause the final harm.
Voluntary, independent, and sufficient in itself.
Yeah. Think about that American case, sometimes cited, People v. Elder, D. Knox v. Unconscious. Then a completely separate bystander comes along and delivers a fatal kick. That kick is voluntary, it's independent of D's punch, and it's sufficient to cause death. D isn't liable for the homicide, only the initial assault. Rafferty is a more recent English case with a similar idea. One defendant's later, independent act of drowning the victim broke the chain, for the others involved only in the earlier assault.
And as we saw, reactions to the defendant's act, like the police in Paget or the medical teams in Smith and Cheshire, are often not seen as truly independent, are they?
Right. There are consequences or responses flowing from the initial act, so they usually don't break the chain unless they're utterly overwhelming and make the original act mere history, to use that phrase from Smith again, or perhaps palpably wrong, like in Jordan.
Okay. Now, there's one specific area where the victim's voluntary act does seem to consistently break the chain based on a major case. Drug supply, right?
Yes, exactly. This area saw some back and forth in the courts. Cases like Finley perhaps focused a bit more on foreseeability.
But the law is settled now.
Absolutely settled by the House of Lords, now Supreme Court, in Kennedy, No. 2. This is a really crucial case to know. Kennedy, No. 2.
Okay. What's the rule from Kennedy, No. 2?
The principle is crystal clear. If a defendant supplies illegal drugs to a victim, and the victim is a fully informed adult who then makes a voluntary and informed decision to self-administer those drugs, like injecting themselves, then that voluntary act of self-administration by the victim breaks the chain of causation between the defendant's supply and the victim's death should they overdose.
So the supplier isn't legally considered the cause of death in that scenario?
Correct. According to Kennedy, No. 2, the victim's own free, voluntary, informed act of taking the drug is the legal cause of death, not the supply itself. So remember Kennedy, No. 2, free, voluntary, informed self-administration breaks the chain from supply.
That's a really important distinction, unless, presumably, the victim wasn't capable of making a voluntary choice or wasn't informed.
Precisely. The Kennedy No. 2 principle relies on the victim being an informed adult making a voluntary choice. If they lack capacity or are deceived about the drug or forced, it's a different situation.
And what if the supplier is like there when the person takes the drug and collapses? Does that change things?
Well, it might lead to liability, but through a different route. Not usually causation from the supply itself, thanks to Kennedy, No. 2. But if the supplier is present and the victim collapses, the supplier might then owe a duty of care to help them, perhaps, because they contributed to the dangerous situation. If they fail to summon help, they could be liable for manslaughter by gross negligence based on that omission to act. Cases like Evans deal with this duty arising after supplying drugs.
So the liability there is for the failure to help after the collapse, not for causing the death by the initial supply.
Generally, yes. The causation link for death in that scenario often stems from the omission, assuming a duty exists. Kennedy No. 2 still governs the causation issue regarding the act of supply itself. So really nailed down Kennedy No. 2 for the voluntary act principle in drug cases.
Okay, voluntary acts, especially informed self-administration of drugs, Kennedy No. 2, can break the chain. What about just natural events, like the ambulance crash we mentioned at the start, or an earthquake?
Good question. Natural events can be a novus actus interveniens, but again, there are conditions. For a natural event to break the chain, it generally needs to be something abnormal, extraordinary, a complete coincidence, truly independent of the defendant's actions, and sufficient in itself to cause the harm.
So if D injures V and V is recovering in hospital and a freak earthquake destroys the hospital, killing V, the earthquake might break the chain.
Quite possibly, yes. Or contracting a completely unrelated fatal disease while in hospital. The old American case, Bush v. Commonwealth, is often cited. Victim was shot, went to hospital, but then died from scarlet fever contracted there, unrelated to the wound. The court held the fever broke the chain. It was the operative cause of death, not the gunshot. Remember, Bush v. Commonwealth.
But what if the defendant's acts somehow made the victim more vulnerable to that natural event, or put them in its path?
Then it's usually not considered a novus actus. If the risk of the event happening or its impact was created or increased by what the defendant did, the chain is generally not broken. Think about Corbett. The defendant assaulted the victim and left him lying semi-conscious or disoriented in the gutter of a road. The victim then staggered into the road and was hit and killed by a car.
So the defendant didn't push him under the car, but left him vulnerable there.
Exactly. The court held the defendant did cause the death. Leaving him in that state by the road significantly increased the risk of him being hit. The car wasn't seen as a fully independent coincidence. Similarly, the very old harlots case, leaving someone tied up in a place where they might be attacked by an animal. If they are, the chain isn't broken because D created that specific risk. So compare Bush v. Commonwealth, unrelated disease, with cases like Corbett or Harlot's case, where D creates or increases the risk of the intervening event.
Wow. Okay.
Sure.
That's covered a huge amount of ground. From the basic tests right through to all these complex intervening factors, it really shows how layered and, well, detailed this area of law is.
It really is, and getting these principles clear is essential. Maybe we should quickly run through the absolute key takeaways, the must-knows.
Good idea. So first we're talking about result crimes, where causation is vital. And causation has two parts. First, factual cause.
Tested by the but-for test, remember White.
Right. And acceleration counts, Dyson, and indirect links can count, Mitchell.
Exactly. Then you need legal cause. This involves a moral or common sense judgment.
And the contribution must be substantial. Benj, not Adams.
And it must flow from the wrongful aspect of the act. Dalloway. Sometimes cases like McKechnie come in here too, where a delay in treating something else because of D's injury contributes.
Got it. Then, the big disruptor, novus actus interveniens, a new intervening act or event.
Crucially, remember the eggshell skull rule. Take your victim as you find them, Hayward Blau.
Then, intervening acts by third parties, the key principle from Smith. The original act must still be a substantial and operative cause. Otherwise, the new act breaks the chain only if it makes the original wound mere history.
Right. Contrast Smith and Cheshire. Medical treatment usually doesn't break chain, with the very rare exception like Jordan. And remember, reactions to danger, like in Paget, usually don't break it either.
Then intervening acts by the victim. Refusing treatment, Holland Blau, usually doesn't break the chain. Escape attempts, Roberts, Williams, and Davis, don't break it if the reaction is foreseeable or within the range of expected responses.
And the very complex area of suicide, Dhaliwal, and especially the Wallace approach, looking at significant contribution and direct response.
Plus the general criteria for an intervening act. Voluntary, independent, sufficient.
And critically, the specific rule for drug supply from Kennedy, No. 2, voluntary informed self-administration breaks the chain from the supply. Don't forget Kennedy, No. 2. And the potential omission liability from Evans.
Okay. And finally, intervening natural events. They only break the chain if they're abnormal, independent coincidences, Bush v. Commonwealth, unless the defendant created or increased the risk of that event happening, Corbett, Harlot's case.
Phew. Yeah, that's a lot. But as you study, really try to recall the basic facts and the core principle that each of these key cases illustrates regarding causation. White, Dyson, Mitchell, Dalloway, Adams, Benj, McKechnie, Hayward, Blau, Smith, Paget, Holland, Roberts, Williams, and Davis. Dhaliwal, Wallace, Kennedy, Nota 2, Bush v. Commonwealth, Corbett. Knowing what they stand for is absolutely vital.
So determining causation in criminal law.
Yeah.
It's clearly not just about pointing to the first thing that happened. It's a really layered process.
Definitely. Applying these specific legal tests and principles to the unique facts, and sometimes, yeah, making a difficult judgment call about what feels fair and appropriate in terms of legal responsibility.
Understanding these principles is just so fundamental for getting to grips with liability in criminal law, isn't it?
Couldn't agree more. It underpins so many serious offenses.
Right. To leave you with something to think about, go back to those hypotheticals in Activity 4.1, the ones we didn't dive deep into, like 4.1d, the father killing the daughter after the rape, or 4.18, the friend giving the strong ecstasy pill which the victim chose to take. Now that we've discussed the eggshell skull rule, intervening voluntary acts, third-party actions, their Kennedy No. 2 rule, how would you analyze the causation in those specific scenarios using these legal principles? Does applying the law lead you to the same conclusion your gut instinct might have reached initially? Or does it force you to a different view?
Yeah, it really highlights that interplay, sometimes tension, between strict legal rules and our broader sense of justice or blame.
Definitely something to ponder.
Well, this deep dive drew heavily on the excellent educational materials made available by the University of London.
And it was brought to you by Sinorbit Academy, Sri Lanka. We really hope this discussion has helped clarify what can be a very tricky topic.
Yeah, best of luck with all your revision, and of course, good luck for the exams.